Hello and welcome to our webinar on employee competition. My name is Roxanne Selby. I'm a solicitor at Fields Seymour Parks, and I'm joined today by my colleagues Bill Dixon, a partner in the litigation team, and also Jackie Denham, who's a senior associate and joint head of the employment team. I'll just begin with a few housekeeping points before we move on. The webinar is being conducted remotely, so do bear in mind there might be technical issues and bear with us with any of those. We'll be taking about an hour today, and that will include 10 minutes for questions at the end. Everybody's muted, and if you have any questions, you can submit them using the questions button on the control panel on the probably right of your screen, and we'll aim to answer those at the end of the webinar, or alternatively, if we can't fit them in, we will email you afterwards and get in touch directly. And you can get in touch directly with us at the email addresses and phone numbers that are on the end of the presentation as well. There will be a number of polls throughout the webinar. Please do join in. We'd love to know what you have to say, and it helps us check that you're engaged and alive and everything like that as well. So that's really nice. You can download the slides while you're online. There's a handouts button on the control panel, or you can download them afterwards. The webinar is being recorded, so you'll be sent a link afterwards. And please do share that link with any colleagues who might not be able to attend now, but might want to watch later. Finally, there will be a feedback form at the end of the webinar. If you would fill that in, we'd be incredibly grateful, just so that we can see what you thought. And also you can enter into a prize draw to win, I think, £50 worth of John Lewis's vouchers, which surely is a good thing. I'd like to win. Okay, so we'll move on and get on to what we're going to cover. So the focus of this webinar, as we've said, is going to be very much on how you can protect your business from any employees or directors you might have who perhaps are going to go rogue and leave the business, or have left the business and perhaps have engaged in misconduct or stolen information. They might be joining competing businesses or setting up on their own. It's something we're seeing as very common at the moment, common to lots of industries: sales, law, insurance and financial broking, IT, also things like shop fitting, and it can be incredibly harmful to people's businesses. So it's a really important issue to think about. The webinar is going to cover 3 areas today. The first area we'll look at is what protections can you put in place and have you got? So I'll be looking at some of the implied and express contractual terms that you might have, and that they might deter people, or that you can use afterwards to protect yourself. We'll then move on, and my colleague Jackie will cover how you can detect any competitive activity. So she'll look at specifically investigations and some of the things you need to think about there, and also issues like privacy that might come up and might be important during those. Then the third thing is Bill will look at what you can do when the worst happens. So specifically, Bill will consider some of the remedies that you might have, some of the factors that you might want to consider, and how you can go about dealing with this problem. And then finally, as I said, we will aim to allow about 10 minutes for any questions. Okay, brilliant. Let's make a start. So I think we were going to begin with a poll first of all. And I'd just like to ask people whether they have any restrictive covenants in their contracts of employment, so that their businesses. I'm hoping probably from the audience that people do, but we'll just give you a few seconds to complete the poll and see what the position is. Okay. Oh, and that's brilliant news that people do have covenants in their contract. So that's probably what we'd expect of the audience that we've got today. I think we've got a lot of HR people and quite experienced businesses. So that's good news. And we'll go on to talk a bit more about those in a minute. So moving back to our slide. So first of all, we wanted to begin with a look at the sorts of protections that you might have or be able to have both inside and outside your contracts of employment. So there are a number of implied and express contractual duties that employees and directors are subject to. These can act as deterrents to people sometimes, and they can also be important in determining the remedies that might be possible, which Bill will go to talk about later. So first of all, I'd like to just talk about some of the more implied duties. These might vary depending on whether people are directors or employees and vary by role. But generally, there's a sort of duty of good faith and fidelity. If somebody's a director rather than an employee, they may have a duty of loyalty as well. And then fiduciaries, such as directors, might have things like duties not to compete, and that might be inside and outside working hours. And sometimes what you might find is there's somebody there's a fine line between competing and preparing to compete. So there's that kind of figure, but there is that duty there. Fiduciaries also have duties to do things like not entice others away or employ them, not to disclose any wrongdoing in relation to confidential information and that sort of thing as well. So again, it's worth if you have a situation where there's somebody who's doing things wrong, to think about some of those implied terms as well. But there's also the express contractual duties. So as we've seen already, people have restrictive covenants in their contracts, and I can therefore assume that they have contracts, which is brilliant news and a good start. Of course, it's not the end of the story. I mean, often contracts can be rubbish, and you sometimes get cases where there either are contracts, but they're very basic, or they haven't got everything in that you need to see. So I would urge people just to go to an employment lawyer, or I'm plugging Jackie's services a bit here, if they want their contracts reviewed, to check that they cover all the things that you need. So one thing that you might want in a contract, for example, to prepare for this sort of scenario, is a right to suspend an employee. I know Jackie's going to talk about that further, and it is quite risky, and there are things that you have to consider when you suspend somebody, and specifically the relationship between the employee and the employer. But that can be a useful thing to have in a contract if you've got somebody who you think is, nicking all your confidential information, printing off your databases, etc. It is something that you might want in your back pocket. Likewise, you might want things like clear provisions for notice periods, what happens when they leave the business, that sort of thing. And you might also want to think about a garden leave clause specifically. I don't want to go into garden leave in too much detail because there's a lot that you could say about it. But it can be an issue where, you've got somebody who's leaving the business, maybe they're in a senior position, they've got access to loads of information, customer contacts, etc. You don't want them nicking it, and perhaps you want to take them out of the business for their notice period. If you don't have an express contractual term for that, it can raise various issues. There's no express clause. There can be circumstances where there's an implied right to work. So the employee might then say, that you've committed a repudiatory breach. They might say that the contract's come to an end without any need for notice. And they might say that all the post-termination restrictions, which you might have carefully crafted, just fall away, and that they can therefore do whatever they want, or whatever. So that's a dangerous position that you obviously don't want to be in. So it's worth thinking about that. And then obviously restrictive covenants, which we'll talk about in more detail now. So as we've seen, it looks as though you have restrictive covenants in your contract, which is great news. But I would urge caution with those. I mean, even if you've got them, it is often the case that they're badly drafted, they've got things in that are not enforceable, or there's something that you've got to be really careful with. And again, I would urge you to get these reviewed, and also get them reviewed regularly, and think about different roles and whether you need different ones for different levels of person in the business. It's really important. You can't just put in anything. They can be an unlawful restraint of trade, and therefore are rendered completely void and unenforceable unless they are drafted in particular ways. So you've really got to think hard about what those are. So to make them valid, and to make it so that they're enforceable, they must protect a legitimate interest. And that protection has to be the minimum amount that's reasonably necessary at the time when they're entered into. So, at the time when the person signs the contract, not, years later when their roles change 5 times and they're in a totally different role. So that's really important. They can be a bit of a minefield. There's a lot of case law on this, not to alarm you, but it can be difficult. But the good news is that the courts do accept that you have the need and the right to protect your workforce and your business. So that they can be used in tandem with other provisions in the contract, and they accept that you might want to protect, e.g., the stability of your workforce. So maybe you've got a small team, it might be a business of 50 people, and if 3 people leave, it can have a huge impact on revenue. And you might want to think about that. Or it might be that you need to protect specific working practices, that you've got unique practices or ways of doing things that are built up over time. It might be you've got a workforce that's really well trained in a particular way, and you're going to be subject to huge loss if they go. So factors like that can give you a legitimate interest in protecting things. And then you've got to think about, well, what protection is necessary and what is it that you're protecting? So, for example, you might want to think about things like geographical location of any restrictions. Obviously, if you've got a hairdresser in Wilmslow, it might be unreasonable to stop her working throughout the whole of the UK. There can be factors like that. Likewise, you might want to think about the duration of any covenants. So, you might want to factor in things like how long it takes to replace people, to get them up to speed, what the renewal cycles are of any products that you've got, how quickly the industry or the market changes, any projects, that sort of thing. And those are all things that you'd factor in to come up with the minimum amount necessary. And thinking what you're protecting then, is it customers or trade connections, goodwill, specific staff, confidential information? All of those things you'd need to factor in when you're drafting them to make sure that they're drafted in such a way as valid. You might want to think about specific non-solicitation clauses, so clients, suppliers, etc. One thing that you can find is that it can be quite difficult to prove that somebody's breached that, have they solicited somebody or whatever. So you might want that kind of provision in tandem with non-dealing. And again, you might want to specify that they can't deal with specific customers or suppliers that, they've dealt with within X period before they left, or to really think about what you need to protect and what the time frame is for that. And likewise, things like non-poaching, that's obviously really significant where you've got teams of people are going, or where you may have teams of people who are going, or somebody who might take, 3 people with them and that sort of thing. And then things like, in your industry, you might have trade secrets if it's scientific or something, and specific confidential information. And again, and with that, you need to think about what exactly is it that's confidential, what are you trying to protect, and how long is it for? So in a nutshell, restrictive covenants and there are contractual protections, but you have to be careful with these and be careful with the way that they're drafted, and get somebody to review them regularly just to check that when something happens or goes wrong, you can deal with the situation properly. So I'd like to pass over to Jackie now to deal with investigations.
Fabulous, thank you, Roxanne. So again, I'm going to start with a poll. This is a kind of basic question, as in, do your contracts and policies make it clear that you monitor your employees? And a simple yes or no answer, really. Let's see, have a look. What was our response? That's very interesting, actually, because I would have expected it to be slightly higher. I'm going to be talking about in my section why it's actually a really good idea to be setting out in your contracts and policies actually whether you do monitor employees. So watch this space, and you might want to be looking at that again for those of you who don't already have that in place. So I'm going to start this section actually by looking at some of the things that might start alarm bells ringing, really, as to whether you need to be suspicious about maybe actions or information that you've received about your employees. Some of the clearest, obviously, situations would be if somebody actually came to speak to you and said, I've been approached by one of your employees talking about future plans they've got, or something about maybe they're talking about setting up in business, and they've even approached one of your colleagues to talk to them about coming with them, or maybe they've approached one of your clients or customers to talk to them about services they might be able to offer. Something as obvious as that obviously would start ringing alarm bells. But you might again find a document or an email. Some people have IT systems that flag particular situations that might mean that you've got some immediate evidence to suggest that someone might be setting up business in competition. For example, if you find a business plan or something sitting on your desktop, which again we have done in the past. So that kind of thing is obviously very obvious, but other circumstances might be less so. For example, generally you need to be keeping an eye out for any sudden changes in sudden significant changes in how an employee is behaving at work. So looking, for example, at their work patterns. If someone is suddenly working longer days, or they're suddenly working in the evenings a lot, or coming in at weekends when you don't expect them to, and they don't need to, and they haven't previously had to, that might start ringing a bit of an alarm bell. Similarly, if someone has been having a hybrid arrangement recently and they've been working from home a lot, and suddenly they need to come into the office in order to use your photocopiers and printers a bit more regularly, again, you might start be questioning a little bit why. Maybe changes in communications might be a bit of an indicator. So someone might suddenly become a bit withdrawn or maybe even negative about your business where previously they've been happy. That might suggest someone was planning a move. Completely at the other end of the spectrum, if someone is suddenly asking a load of questions about the business that they hadn't been at all interested in previously and don't really need to know for their role, maybe suddenly asking how your account systems work, or maybe how you carry out recruitment or marketing, that kind of thing. Again, you might be wondering why they're suddenly interested in that. Any unusual behaviour obviously would be a bit of an alarm bell. For example, very obviously, if someone starts doing a load of photocopying and printing and they don't need to for their role, you might be thinking, hang on a minute, what's going on here? But it might be something more subtle, like suddenly attending or asking to attend a lot of training sessions when someone's not been that particularly interested in doing so previously. Maybe they are thinking about upskilling themselves before leaving. It might be that they suddenly want to attend networking and business development events that, again, they've not been particularly interested in doing so before. So, and maybe just asking lots of questions about your current clients or wanting to meet them in person. Again, start being a little bit wary of that unless they absolutely need it for their job. Obviously, all of these things are going to could have legitimate, reasons why someone's doing it that isn't to do with them potentially, planning on leaving and causing you damage. But they are worth always having a bit of a question as to whether it's all okay or not. So moving on then, if you have got any suggestion that someone might be going to try and preparing to compete with you, or otherwise misusing your confidential information either for their own use or for someone else's use, then you obviously have got a bit of a gut reaction to want to start leaping in and making sure that that's not the case, or properly investigating it. But what I would say is, before you start your investigation, you need to take a few steps and kind of step back and make sure that you are going to be compliant with all the legislation that does apply to that kind of intrusion into someone's privacy. But you also need to make sure that the investigation is run in a way that is as thorough or as useful to you as possible before starting. So one of the things obviously that you're going to want to do is looking at people's email, phone and internet records. They might potentially have downloaded information onto a USB or even a DVD. They might have information on an iPad or a work phone, all that kind of thing. So that one of the first things you need to look at is trying to retrieve that equipment so that you can carry out searches. Now, hopefully you will have a contractual term that allows you, or even a policy that allows you to request the return of company equipment on demand at any time. So hopefully you'll be able to rely on that. You need to be thinking about instructing legal advisors right from the outset. And obviously I would say that to very important people, very useful, but actually there is a good reason. When you're carrying out investigations such as these, you might want to try and claim legal privilege over what the documents say or what the investigation report says. And in order to do that, you might need to be very careful about how that investigation is run. If a document is prepared in contemplation of existing or contemplated litigation, then you might be able to claim legal privilege over it. Or if it's produced in order to obtain legal advice, again, you might be able to claim legal advice privilege. So it's worth speaking to lawyers from the outset as to how to run the process if that's what you intend to do. Similarly, they can also, obviously, as Roxanne's also mentioned, they can actually take a look at the restrictive covenants or confidential provisions you're trying to protect or that you would like to enforce, to make sure that they are likely to be enforceable. What you don't want to do is spend a load of time and money on legal fees, management time, management costs, investigating this thoroughly, if ultimately any restrictions you've got might be challengeable by the individual anyway. So it's worth doing that from the outset. The other thing to think about right from the outset is whether you need to instruct some forensic IT specialists. In some circumstances, you will need to make sure that you effectively take a mirror image of the screens and the records and the IT use of those individuals prior to starting search, because by carrying out a search, if your IT searches are not carried out by somebody who knows exactly what they're doing, you could potentially actually damage the integrity of the evidence that you're collecting, which might make it difficult again to enforce some of these provisions. As Roxanne mentioned, you need to be thinking about suspension. It might be appropriate for you to suspend an individual with pay whilst you're investigating. Obviously, the benefit of that is that you can prevent them from tampering with evidence potentially, or obviously prevent them from being able to access your IT systems to be able to take even more information with them during that time. However, we do need to be careful with that. As Roxanne said, you need to be careful that you do have the right to suspend, and that you're not potentially causing a breach of contract yourselves, and that they could then rely on in order to say that the whole of the restrictive covenants in your contract are not enforceable. But also you need to be a little bit wary of, are you going to tip them off by obviously suspending them? They might be tipping them off that you're about to carry out an investigation, which might mean that any evidence they've got at home, maybe if they have taken hard copies of things, for example, they might immediately destroy it and make your position a little bit more difficult. So it's just need to be very careful with that. And again, just generally before you start any investigation, you need to be very careful that you've agreed what the scope of that investigation looks like. What you cannot do is just a general fishing expedition looking for bad things that people might have done at some point during their employment. That's not acceptable in terms of many different things. For example, in terms of how you treat, just generally treating employees reasonably, but also there's massive privacy issues with taking that approach, so you need to be careful. So moving on then, when you do start your investigation, some of the other points to be thinking of is privacy. Privacy is so important because actually there is so many different pieces of legislation that might be relevant. Just generally speaking, Article 8 of the European Convention on Human Rights and the Human Rights Act gives everybody this right to respect for private and family life. However, the important thing to remember is that that does only apply where an individual has a legitimate expectation of privacy. So what that means is that it is therefore incredibly important for you to have, as I said before, these policies, privacy notices, contractual terms that make it very clear what that expectation of privacy is in an employment context. Individuals should be very clear as to what your expectation is as to whether they can use your computer systems for any personal use, and if they do, what kind of rights you have as a company to be searching through some of that stuff. What you might find is that individuals mark particular emails as personal or private, and obviously in that circumstance you need to be even more careful if you're starting to search it, that you've got the right to be doing that, and that they understand that that is a possibility before they start using your computer systems. Generally speaking, you need to be proportionate with your approach on these things. The General Data Protection Regulation and the Data Protection Act 2018 are much more onerous in terms of general privacy rights. You need to be thinking generally about being very transparent with individuals, because the Information Commissioner's Office essentially just have made it very clear that any kind of monitoring or searching of employee information on your computer systems will be considered to be intrusive, and therefore you need to have a lawful reason for doing it. Now, obviously, protecting your confidential information and your trade secrets, and trying to protect yourselves from damage caused by anybody from breaching those is likely to be a legitimate interest. But over and above that, you also need to make sure that you are being very reasonable with your approach to enforcement. So when you're doing your investigation, you need to make sure that it's necessary, it's justifiable, and it's proportionate. And what that means is essentially, in order to be necessary, it has to be that someone is likely to cause you damage, and that damage is serious enough for you to need to start an investigation into it. And that will very much depend on what someone's role is and whether they actually have access to information that could cause you damage. Again, you need to be thinking about, okay, justifiable. Yes, I've got a legitimate reason why I want to do this, but actually, is there potentially another way I could go about searching or finding the information without doing something quite so intrusive as searching everybody's records? Again, in these kind of circumstances, when someone's leaving your company and you've got suspicion they might be doing something with your in breach of your restrictive covenants, it's unlikely that there's an easier way of doing that's less intrusive. You know, if you just went up to the individual and said, okay, I think you've been doing this, can you show me copies of what you've been up to? They're probably not likely to comply, but it's worth having the thought process so that you can explain it to the Information Commissioner's Office if necessary. You also need to be thinking about just generally this principle of proportionality. Is the extent of your monitoring reasonable? You don't want to be looking at everything, as I've said before. If you're suspicious that someone's been doing something in the last few months to prepare to compete with you, you're only going to want to look in terms of the timescales of things that have happened over the last 3 months. It wouldn't be reasonable for you to be searching all their records going back a few years. So the general scope of your search needs to be reasonable and justifiable. But again, over and above that, you need to be really conscious of just general privacy principles, which is around making sure that those search results that you then receive are kept securely somewhere, and also that you're restricting the access to that information that's revealed as far as possible and reasonable. So you might need to just restrict it to the people who are carrying out the investigation and the people that are making the decisions if ultimately you decide you need to take formal action in the form of a disciplinary or taking any of the actions that Bill's going to come and talk about later. Because when you're processing this kind of personal information this way, so you're effectively investigating somebody to see what they might have been up to, that's likely to result in a high risk to individuals, because ultimately it could result in them losing their job. In those circumstances, you're expected to have carried out a data privacy impact assessment. And essentially that's looking at all these different things that I've already been talking about around, can you do it potentially in a less intrusive way? Have you thought about limiting the scope of the search? Have you made sure that it's justifiable, the approach you're taking? Have you thought about limiting the access to the results? How will you keep it all secure? All of those things, you've got to document that thought process. Now, some larger companies might just already have a data protection impact assessment nicely drawn up in a lovely table that covers all monitoring of employees. But if you don't have that, prior to starting the investigation, it's worth doing the thought process and noting it down, even if it's not in a beautiful format. At least it's a written document you could share in the event of a challenge. The other thing to think about is you might have notification obligations. Now, if, for example, whilst you're doing the investigation, you find out that actually there's some of personal data belonging to an individual has been sent incorrectly outside the company, for example, you might have notification obligations to that individual or to the Information Commissioner's Office itself. You might, similarly, if you find out that confidential information belonging to a third-party company has again gone outside your company, that you might have notification obligations under your contract with that third party that you need to inform them that what's happened. Similarly, if you're regulated, there might be a regulatory body requirement for you to disclose certain things if you find out that information has gone outside your company. For example, if you're regulated by the Financial Conduct Authority, that might be the case. The other thing it's worth me highlighting is that there are additional obligations on companies that actually most people or many people do not know about. For example, the Investigatory Powers Act 2016 and the supporting regulations actually does apply in any situation where you're intercepting or monitoring emails and phone calls. So it could be an offence under that legislation if you start doing it, unless you're an employer that has the right to use, obviously control the use of your email and phone system, and that monitoring those communications is actually in relation to the business and the course of your business, or that you've obtained specific consent to it. And again, all of that suggests that you can do it as an employer, but the benefit of having your policies and your privacy notices and your contracts being so clear about what monitoring you do, what control of the systems you've got, is so important to make sure that you're compliant with that legislation too. As Roxanne mentioned previously, one of these other really important things to always bear in mind when you're investigating employees is that you do have this implied term in all employment contracts of mutual trust and confidence. If the way that you carry out your investigation is unreasonable or unjustifiable, then that breach could potentially allow an individual to resign and claim constructive dismissal. Because you will have then carried out a repudiatory breach of that employment contract. They are no longer bound by the terms of it. So that means they are no longer bound by any of the restrictive covenants or confidentiality provisions in those contracts that you are seeking to enforce. So it's particularly important that you carry out a reasonable investigation and that you're always thinking about whether the approach you're taking is justifiable. Other risks to bear in mind is obviously if the individual is still an employee, obviously you've got this risk of whether they could resign and claim constructive dismissal, but even if they don't, they could bring a grievance, which obviously is, in terms of management time and pay, a little bit something to bear in mind to try and avoid. Separately, if they think that you have breached any of your privacy obligations, they might raise a complaint with the Information Commissioner's Office, which could result in an incredibly painful investigation just generally, because the Information Commissioner can come in and try and ask you lots and lots of questions around how you just generally manage data within your business, or it could result in an enforcement notice or even ultimately quite a hefty fine. And separately, an individual can obviously claim for compensation for any damages or distress caused if you have breached some of these obligations. Hopefully all of that information hasn't terrified you, but generally will give you all the information you need to be able to carry out an excellent investigation if you need to, which will allow you to obviously take steps to then protect yourselves from damage. And Bill is now going to cover that section of how we can go about actually trying to protect ourselves in the court.
Good morning, and can I just briefly apologise in advance? I have been having some camera issues over the last 15 minutes or so, which my technical skills aren't sufficient to be able to fix it. I think it's a hardware issue, but apologies, do not adjust your sets if my image suddenly starts developing some squiggly lines. So as with the previous sections, we're going to start off with a very quick poll. And what we are interested in knowing is, have you as a business ever had a problem with rogue employees leaving and setting up in competition? And I'll give you a few seconds to select an answer. Okay, so 41% have had a problem, 59%, the majority, have not. So the ones who have had this problem, you are probably already aware to some extent of some of the issues, and hopefully I can help the 59% who are lucky enough not to have had this problem yet, what some of the issues might be. So what I want to look at is, what can you do when the worst happens? So you've done your best to draft your employment contracts as well as you can. You've put in carefully worded post-termination restrictive covenants. You've got a little bit suspicious for some reason. You've carried out an investigation, carefully bearing in mind all of Jackie's tips and recommendations, and you've got to the point where you are either certain somebody's up to no good, or you've got a pretty shrewd idea that it's happening. So to what extent can the law or the court system help you in this situation? I think the starting point, has to be with the employment contract. If you believe that employees or ex-employees, if they're still within the period of the post-termination restrictions, are wrongfully poaching your customers or taking confidential information or trying to entice away your current employees, then it will probably be the case, if you have a well-drafted contract, that there will be clauses in the contract that you can rely on to bring legal claims against your employees. Now, all is not lost if the employment contract does not help you, because there may be other reasons and other ways in which you can still bring a legal claim against employees or ex-employees. As Roxanne mentioned at an earlier point in the talk, particularly with senior employees, with directors, they may owe fiduciary duties or even Companies Act duties, which apply irrespective of what their contract of employment say. And it may also be the case that if you look at what it is an individual is doing, you don't really need a contract right to bring a claim. There may be general duties of confidentiality. There may be breaches of IP rights. Quite frankly, in an appropriate case, there may even be issues of fraud or theft. So all is not lost if your contract of employment isn't drafted quite as well as it should have been. Let's assume you didn't come to Field Seymour Parks. You may still have other types of claims that you can bring against employees or ex-employees. Now, the interesting area is when you begin to move beyond people you employed or once employed and look at the issue of third parties. So, for example, you may have an individual or a group of individuals who have gone off to join your biggest competitor. You may have people who have set up a brand new business, but they may have also done this together with other people. There may be other third parties involved funding the business or indeed working within it. So can you also bring claims against those third parties? The answer is yes, you may be able to do that. In particular, they may be liable for inducing breaches of the employee's employment contract, and they can also be liable for conspiracy claims. The main essence you need to show is that there's some sort of degree of knowledge on the part of the third party of the wrongdoing, and then potentially you can have a claim against the third parties. Now, there are some quite cogent strategic reasons why you may want to at least look about going against this category of defendant. Individual employees may not have vast financial resources. These may be individuals with limited financial means. If you go against their new company or the other people they've set up in business with, two things may quickly happen, either of which would be very much to your advantage. First of all, you may create a wedge between your own staff who've left and the new people they've gone to work with. It may be that the new employer or the other people involved in the new business didn't really appreciate the extent of wrongdoing. They may get badly scared by the implication of getting legal letters, and they may decide that they will just back away from the situation and cut the individuals loose. Or alternatively, you may find that you cut off financial support from these individuals and they are left to fund any legal defense on their own. So if you possibly can do so, it is always worth looking at the position of third parties. So moving on. I've talked about where you may have claims, what sort of claims you may have, who you can look at going against. What I now want to turn to is exactly what sort of legal claims you might consider bringing. Now, there is a ladder here in a way. There are different levels at which you can pursue potential defendants. And unfortunately, you may not be surprised to hear that there is a bit of a trade-off. So there are remedies which the courts will potentially give claimants, which are absolutely fantastic. They are very effective, they're very draconian, but the problem is they cost a lot of money. So what you have to do at a very early stage is come to some sort of cost-benefit analysis. You really have to decide what is the potential for this wrongful activity by my employees or ex-employees to damage my business. How important is it to stop this activity? How much do I want to spend? Because as I say, I'm going to describe some remedies which are very draconian indeed, but they come with quite a hefty price tag. So I think it is useful to look at the legal claims and steps you can take by way of levels. And at the lowest level, you could simply get your law firm or your in-house lawyers to send letters, perhaps demanding undertakings that people will stop wrongfully soliciting customers or doing other things that they shouldn't be doing, perhaps committing that they will return laptops or other devices that they shouldn't have, agreeing they will return or destroy confidential information. So you can simply try and deal with this by aggressive legal letters. That might work. In particular, what you may find happens is that the individuals who receive these letters take these letters to another law firm who perhaps advises them, look guys, you are seriously at risk of going down if there is a lawsuit. You potentially could face claims of tens or hundreds of thousands of pounds. Your best bet is just to try and avoid all this and do the best deal you can as early as you can. So level one, send a letter, perhaps demanding undertakings. That may not work, or you may feel that the circumstances demand tougher action. Level two is probably starting traditional county court or high court legal proceedings. So what you would do is you would issue proceedings at court. You would set out a claim for damages, a claim perhaps for an account of profits. You might want to claim a permanent injunction once the case got to trial. You would pursue that case through the courts, and if it didn't settle, you would eventually get to trial in perhaps 12 months' time, 18 months' time. And then if you win, you'll get a permanent injunction, you might get damages, you might get an order for an account of profits. The problem with this is, as I've explained, this could take 12 to 18 months before the case comes to trial. Maybe the defendants will be so scared by the implications of what is involved in these proceedings that in the meantime they will stop further competitive activity, but you can't guarantee that. Maybe that in the meantime they will carry on trying to poach your employees or try to carry on poaching your customers. So it may not be realistic to wait for 12 to 18 months, but if you can wait, level two is basically pursuing ordinary proceedings to trial. And just to explain the difference between a damages claim and a claim for an account of profits, a damages claim in this context is looking at the financial losses you as a business have suffered. That can be quite an involved calculation. Indeed, you may even want to bring in a forensic accountant to help you differentiate what are your net losses, what costs did the investigation say can you claim for, but the emphasis is on what you have lost as a business. Now, in some cases, that's quite hard to calculate. You may be pretty sure that this new business is damaging your own business, but it's hard to get hard, concrete data as to what your actual losses are. And the courts recognize that to some extent. And in some instances, an alternative approach from the courts is to give you an account of profits. Now, basically what this is doing is the courts are saying it is wrong for a new business to be set up based on misuse of your confidential information, wrongful soliciting of your customers, wrongful poaching of your employees, because this new business has in effect given itself an unfair leg up. Maybe they've been able to get into the market and establish themselves 6 months quicker than they would have been able to do if they'd done this properly, if they'd gone by the book. Therefore, you as a claimant should be able to get an account of the profits the new business has made for that 6-month springboard period, which is the unfair leg up they gave themselves by setting up a business on the basis of breaches or wrongful activity. So that's what an account of profits is. So what about the really strong stuff? What if you are faced with a situation which is potentially business critical? There's no point in writing letters or starting legal proceedings because real damage is being done to your business now. You just don't trust the individuals involved. You have got to stop the rot as strongly, as powerfully, and as quickly as possible. So this brings me to the highest level of legal action. You may want to go for an interim injunction or an interim court order. And just to explain what an interim order is, this is going to the court and saying, Judge, I cannot wait 12 months for this case to come to trial. I know you haven't heard all the evidence. I know you haven't heard all the witnesses. However, I have at least a strong enough arguable case now that I should be entitled to temporary interim protection. So until this case comes to trial in 12 months' time, I want an injunction stopping this business from contacting certain customers, or I want an initial court order that they deliver up certain confidential information. The courts will grant these orders in an appropriate case, and they are very powerful weapons indeed, primarily because of the consequence of breaching a court order, even a civil court order, is that you are in contempt of court. And if you are in contempt of court, potentially in a serious enough case, you could go to prison, even in civil proceedings. So very hard to ignore interim injunctions and interim court orders, and all sorts of very powerful provisions can be added in. And at its most draconian, you can get what is called a search order, which is in effect a civil search order, where in theory, if the circumstances are serious enough and you can make out a case that satisfies a judge, you can send your lawyers to your competing businesses, new business premises, even their home addresses. Those lawyers can knock on the door, brandishing a court order, and without any advance notice whatsoever, they can demand to enter the business premises, to enter someone's home, and they can then search the premises for wrongfully obtained confidential information, or they can access computer laptops, devices, and they can make sure that they obtain images of the material that's on laptops and computers. So potentially a very powerful weapon indeed. And what I've quite often seen in this most extreme situation is, in practice, a new business can be destroyed almost before it's got going, because if you have to engage a law firm to cope with a full-blown search order, a full-blown interim injunction in circumstances where the lawyers have got to spend a hell of a lot of time making sure that their new clients comply, you can sometimes find that the new business just gets crippled right from the start. They have massive legal costs, people who are funding the business, potential other employees get scared away, and the whole competing business can just collapse right from the start. So aren't these remedies great? Absolutely fantastic. However, there are two catches. One, as I mentioned at the outset, very expensive to get these orders. You're talking about many tens of thousands of pounds right from the start of the case. And there are some very important protections which are given for defendants just because these remedies are so draconian. So first of all, if you go and get one of these court orders without any advance notice to the defendants at a court hearing where they are not present, you are under a duty as a claimant to give full and frank disclosure to the judge. And what that means is you can't just present the claimant case, you actually have to give the judge a fair idea of what some of the defense arguments should be. If you don't do that, the order could automatically get set aside later. That's protection number one. Protection number two is you have to give what is called a cross undertaking in damages, which means you promise the defendant that if in 12 months' time, when this case gets to trial, it turns out you didn't really have a case, that you should never obtain the temporary injunction, you have to promise the defendant that you will compensate them for any losses their business has suffered over that 12-month period before the case got to trial. And there are then other ancillary protections which the courts put in place, in particular with this most draconian remedy of a civil search order. The claimant has to pay for an independent lawyer from a totally different law firm to attend on the search and just monitor and watch what is going on so that the claimant's lawyers don't abuse this incredibly powerful weapon they've been given to go into someone's business without notice, or even to go into someone's home without any advance notice. And the final remedy you tend to get with these orders is they are always capable of review. So you can't simply get your order and then sit back and say, this is great, I've got my interim injunction, now I can just sit back and wait for the trial. It's always open for the defendant to go back and argue at other interim hearings that the order is too wide or it was wrongly granted. So you could get sucked into a long series of interim court hearings that are very expensive long before the full trial ever comes on. So as I say, the key issue here is think very carefully about how serious the potential damage to your business is, and think at a very early stage about just how far you want to take it. So that is all I wanted to cover. We are now going to give you an opportunity to ask questions if you would like to submit those. If we don't get time to get on to your question, or if you're not quite quick enough on the keyboard, you can email them in later and we will endeavour to answer them.
Bill, I do have a question that's come in for you. Can you give us some explanation as to how strong your evidence needs to be to get an injunction?
You have to have what is called a good arguable case. So the courts recognise that they are granting an injunction ahead of a full trial. So they realise all the documents aren't available. Maybe even the defendant hasn't had a chance of putting their side of things at all. No witnesses have been cross-examined in court. So inevitably, to some extent, it's a rough and ready assessment, but it just has to be a reasonably arguable case. I think it's probably fair to say that judges are human beings. They are probably slightly influenced by the seriousness of the accusations and the potential for harm to a claimant, as against the potential for harm to a defendant. So to some extent, as well as weighing up just how strong the evidence is, they are also weighing up who could be hurt the most if they grant a temporary injunction, as against if they don't grant a temporary injunction. I think in my experience, quite often judges tend to play safe, and they tend to say to themselves, I'll grant the injunction. If I'm wrong, no harm done, because the defendant can always come back later and try and get it set aside.
Thank you. There's a question for me around, can you carry out these investigations covertly? And I guess the typical employment law answer will be, it depends. Again, this kind of links back quite a bit to the decision around suspension, and whether actually, if you think there is a risk or a genuine risk that they might tamper with the evidence, again, you might therefore, for that reason, be thinking around suspension, and then thinking around, okay, we'll do a covert investigation prior to suspension in order to make sure that we've got actually an idea of what's going on before the individual has an opportunity to try and backtrack on what they've been up to. But essentially, you need to be looking again, do you have the right to do covert surveillance under your policies and contracts in certain circumstances? And similarly, you just always need to be bearing in mind this idea about being necessary and justifiable and proportionate. So it very much will depend on what you think the reasoning is behind why it has to be covert in a particular circumstance, and make sure you've jotted down your reasoning behind that. The most, I guess, draconian type of covert surveillance would be something like installing CCTV without telling anybody, or even private surveillance. You know, people do sometimes hire private investigators in certain scenarios. That, I guess, is considered by the ICO to be incredibly huge intrusion into someone's private life. So in those circumstances, it might even be considered harassment. So you really do need to be very careful to make sure that in those extremes that you have really properly thought out that there is no other way of gaining the same evidence without being quite so, I guess, intrusive. The only other question I've got at the minute is, what if an employee has committed a crime? Is there any difference in approach you might take there in terms of getting the police involved, Bill?
I think there are two tendencies here which perhaps pull in slightly different directions. On the one hand, even if particular conduct is technically a crime, in reality the police are quite under-resourced, and in the minds of the police and the prosecuting authorities, they quite often regard something as a civil matter, even if in reality it is a crime and they are reluctant to get involved. However, in a case of serious financial misconduct in particular, if funds have been stolen, not only will the police get involved, but these days they have their own police equivalents of freezing injunctions and interim injunctions that you can get from the civil courts. So on occasion, that can actually be a cheaper way of trying to freeze money in a bank account before it disappears. But I think in most instances, you'll probably struggle to get the police interested.
Okay, I have had one other question in which I will email the answer to because we've kind of run out of time. I'm conscious that it's very much 11 o'clock now. So I guess it just remains for us to say thank you to everybody for joining us. There are contact details on the slides. Please do feel free to get in contact if you've got further questions, want us to take a look at your contracts, for example. Thank you very much for joining us, and thank you to Bill and Roxanne too.
Thank you. Bye.
Thank you.